Next, from Springfield, we speak with Attorney Aaron Maduff, representing the State University Annuitants Association in their lawsuit against the state of Illinois regarding the pension reform law passed in the spring. We get an update on the progress of that lawsuit. This runs about 12 minutes. Aaron Maduff, thanks for joining us again on the Illinois channel, and we appreciate you taking the time to update us as the lawsuit that SUAA is filing and bringing against the state of Illinois vis-a-vis the pensions is proceeding. Today there was another hearing. Can you give us off the top what was the significance today of what happened in court?
Today's hearing was primarily a scheduling hearing. In June, all of the plaintiffs filed a joint motion for summary judgment stating that the reserved sovereign powers, or the police powers, do not apply to the pension clause, which protects pensions. The court at that time put that motion off because the state said we want to put the entire case before the court, which would include the reasons why the state is in a situation that it is permitted to exercise its police powers. Then after the Canerva case came down, we again filed motions. The SUAA filed a motion to strike that affirmative defense. The other groups also filed a motion for judgment on the pleadings, again arguing that it doesn't matter because the reserved sovereign powers do not apply to the pension protection clause. On October 3rd, the state filed one response to all three of those motions, and it filed a motion for summary judgment arguing that not only do they have the right to exercise their reserved sovereign powers, but they meet the very high burden that says that this is an emergency such that we need to exercise those reserved sovereign or police powers as we've called it. So today we came before the court to discuss scheduling. How are we going to deal with these various motions? The state stuck to its view that we should handle everything at once. The problem with the state's view is that if we are going to have to also argue about whether or not it's met its burden, the plaintiffs groups are going to have to take depositions of some 6 or 7 expert witnesses. We're going to have to gather lots of information about the budget, spending, and there's just a tremendous amount of work that needs to be done that will take us well into next year.
In our conversation that we had just before we started talking on camera, I think in essence you were saying if the court, and again this is at the circuit level right now, if the court were to say, state in the court's opinion you cannot invalidate the pensions vis-a-vis the police powers argument, then there's no point in arguing all the rest of it because that would kind of gut the state's argument. And you would just then jump to the Supreme Court and have them review it, in which they would either affirm the lower court's decision or they could overturn it. Is that in essence?
In essence, that's where we're going, right. Because if the circuit court concludes that you cannot use the reserved sovereign powers, then it doesn't matter if we are in such a state of emergency that it reaches that level of permitting the state to invoke the reserved sovereign powers. It doesn't matter. So what the court did is it agreed with the plaintiffs and said, we're going to address that question first. The plaintiffs groups have to file their motions or their reply by October 31st, and the court has set a hearing date for November 20th. At that time, the court may rule. It may hear arguments and then take it under advisement and rule, but it is put the question of whether or not the state has met the burden under the police powers aside for the moment. If the state rules in favor of the plaintiffs on that issue, then it can enter a permanent injunction and close the case. The plaintiffs would win at the circuit court level. At that point, there's the possibility of an appeal to the appellate court level, but in this situation, there's also the possibility that it goes directly to the Illinois Supreme Court. At that point, the Illinois Supreme Court will review those arguments all over again and make a determination, do the reserved sovereign powers apply? If the Supreme Court agrees with the circuit court's finding, agreeing with the plaintiffs that they do not apply, then the case would be over. If the Supreme Court said no, they can apply, then we go back down to the circuit court and we start addressing the state's arguments in terms of does it reach that level that we bring in the police powers.
And let me kind of use an analogy that people would be familiar with. I think when we look at what happened in Ferguson, Missouri here recently, where you have the whole rioting and all, and the police had to come out to quell the disturbances. In essence, that is emblematic of what the state would argue, that there are going to be times when we have to have the power to maintain the general law enforcement and welfare of the whole society. We can't be gutting our police force, our ability to manage the state, and by diverting so much funds to the pension that it, in essence, makes us incapable of providing that protection. Is that
That's pretty close.
Somewhat of a fair argument?
The concept of the police powers is that we have rights as citizens. The Constitution gives us rights, the laws give us rights. And the reserved sovereign powers or police powers is an opportunity for the state or the government to abridge those rights, irrespective of the fact that they exist in the case of an emergency. The classic situation that we think of is martial law, when you've got literally the military governing the streets. Now, we haven't seen that in a very long time in any part of this country, but when you talk about what's going on in Ferguson, Missouri, you're giving an example of where the National Guard, for example, steps in and uses a little bit of that, and that has a tendency to abridge rights even though they exist. The state's argument here is that the state's fiscal condition is so bad that we have to take away people's pension rights and simply not pay them, renege on them, because we don't have the money. And we're going to have a lot of arguments as to why that's the case. Has the state been wasting money elsewhere? Are there other ways that the state could have the money? Is this something that was foreseen or unforeseen, et cetera? So there are a lot of arguments that will go into that. But that's if you get to that reserved sovereign powers defense. And certainly we understand when you talk about the right of people to be secure in their homes, there are reasons that the state can violate that. And so now we're going to try and shift that imagery, if you will, to taking people's pensions.
One of the things we talked about, let me just go on a slightly different topic, but one we talked about in the past, the question was about the monies that were being collected for the employees, state employees to be paying for health care. That had been invalidated through the Canerva decision on July 5. I think last time you said that it was maybe they should stop coming out of their paychecks maybe in October, but certainly by November. Was anything new to update us on that?
Yes. It's my understanding that people did not see deductions for health care come out of their October 1st checks. Obviously, people are going to look at their individual checks, and there might be checks sent out at different times. But my understanding is that people who were seeing deductions should have stopped seeing those deductions if they look carefully at their October 1st checks.
And can you remind us what was the situation with the monies that had already been taken out? Is that going to be returned to those individuals, and do we have any kind of a timeline on that?
That's still a fight. There is money that is in various accounts that the state has. And on November 21st, we will be appearing before the judge in that case to argue over how to recover that money. It is a complicated matter. It needs some unwinding. There's going to be some work to do. Our goal, of course, is to get that money back into the hands of the service members from whom it was taken.
Let's going back then, to the whole argument of the lawsuit against the pensions. If the lower court on November 20th says guts the state's argument, the police powers cannot be used as a reason to diminish the pensions, then it would be going to the Supreme Court. Long story short, but do we have any kind of an idea of the time frame? When would you guess that would go to the Supreme Court?
Well, I think that we're assuming that the state's going to go that way, and I would suggest to you that there's never a guarantee. And I know that a lot of people...
So let me insert. So if you win at the lower court, it would be the state that would take it to the Supreme Court on appeal.
Right.
But they might say, let's not bother and just drop it at that?
No, I doubt that. The state's made it very clear, I think, that they will take it up.
Okay.
But what I think we need to be careful about as a precursor to your question is, where do we stand on this? The Canerva decision came down, and many pundits and spin doctors have said that forecloses the issue, it's all over. And that's a serious, serious mistake. The Canerva decision certainly gives us reason for optimism. It gives us arguments. But this is not over. The Canerva decision does not foreclose entirely the possibility of the police powers being used. We believe that there's other law that we're going to argue does, but this is not an issue that has been decided by this court, and this court is going to decide it. And anybody who is sitting there saying, it's all over, we won Canerva, why are we still here? Well, it's because it is a different issue, and this court's going to have to make some determinations. So we do have a great deal of work that has to be done. There is a fight here that has to be taken care of. Canerva has not ended it. What we will be addressing in our briefs and what comes up on November 20th as to whether or not the police powers can be applied to the pension clause is, in a sense, its own fight. Once that is taken care of, if we win, then at that point we can expect the state to take it up. So I now address the question you started with, how long will that take? The judge has set a schedule for November the 20th. We can be assured that we're not going to have a determination before then. On November the 20th, we may have oral arguments after the judge has read the briefs, and the judge may at that point issue a ruling, or the judge may say, I want to think about this and write out an opinion because I know that this is likely to go up to the Supreme Court. If the judge rules in our favor and he wants to take the time to do that, I would anticipate, based on things he said, that he'd like to do that by the end of the year, and we can anticipate that sometime in January the state will appeal that up to the Supreme Court. If he rules against us on that, and he has certainly not given an indication of which way he's going to rule, if he rules against us at that point, that's in the record, but we can't necessarily take it up at that point. We now have to address, has the state met the burden of an emergency? And there is a tremendous, tremendous amount of work to do. The good news is that the injunction that we have will be kept in place during that time. And so we won't see anything happening. But if we were to say, okay, fine, and walk away from the case, then the state would have no opposition to its defense, it would presumably prevail, and the injunction would be lifted. So there is work that has to be done.
Okay, before we close out, are there any other points you want to make?
I think that covers it. Thank you, Terry.
Thanks so much.